people want
I'm trying right now.
to write their own program. Guess what? If you could write your own program, we wouldn't even be here because you would have written your program and you would have been successful and you wouldn't have been with some random guy that you don't know and y'all using random drugs.
That was
Welcome to the Court of Justice.
Court is calling 2023 CR 9542W State of Texas versus Ashley Marie Hernandez. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense.
Attorney Bill Simmons for defense.
And are you Miss Hernandez?
yes, ma'am.
Counsel, have you received all the discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Hernandez, I'm going to show you what's entitled Waiver of Indictment, Reading of Information and Rights under Article 1.051 and 26. Oh, shucks. Sorry. Court reporter. Y'all just letting me go in the court reporter.
I didn't.
Hey, you guys, we will not let her know that we did not know she was here. That is one of the most important people.
Cut it from the street.
Okay.
Yeah.
Oops.
I remember in high school, we were doing shorthand and you had to take the shorthand course, which is what court reporters used to do.
Yeah, it's all.
I don't know how they did that.
I made a rec on that.
Still trying to figure out the
I
point
probably should have
when
a little bit to the court.
the
Probably
decision was made to quit teaching cursive, because I thought we learned how to write cursive in like second, third grade.
Yes.
So like, did they
They
just
just
say they're
decided-
not doing it anymore?
And you know, I had a client once. I told them to sign their name and they just printed it.
Yeah.
And they said, I didn't learn. What is this thing you're talking about cursive?
Oh, I refuse.
They can't even read it.
You can't read my cursive, but you can read when I write things just. as you're
Well, you know what I think when it stopped? When they got rid of handwriting.
But I'm just trying to figure out, that used to, my first memories of school are,
The handwriting,
Writing.
yes.
that's all, so I'm wondering, when did they just decide not to do it?
I never, you know what, one of the worst letters for me? The letter K. When you think about doing the lowercase K for cursive, that was hard.
I was in, it was cute. You know, they drilled us on that, but like I said, especially with juveniles, they can't even read it.
Oh, you can't?
Cursive. Even if it was, you know, and I'm, like I said, I'm just trying to figure out when they quit teaching. Because nobody could tell me, that's my.
Yeah. Mr. Hernandez, if you want to have a seat till the court reporter
Yes,
comes
ma'am.
back, you can.
Attorney Bill Simmons for defense.
And are you Miss Ashley Hernandez?
Yes, ma'am.
Counsel, you received all the discovery. Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Hernandez, did you review the document entitled Waiver of Indictment, Reading of Information and Rights under Article 1.051 and 26.03 of the Code of Criminal Procedure with your attorney? Did you understand it
Yes, ma'am.
and did you sign it?
Yes, ma'am.
All right, who's in the, out the record? Who's that back there? Oh, sure. Okay, no problem. Oh, no problem. All right, did you understand? We're back on the record. Did you understand that you have a right to have a grand jury hear the evidence in this case and make a decision on whether or not this case should be held over for trial?
Yes, ma'am.
Did you understand your attorney has certain rights, namely 2 days from the presentation of the information and 10 days from the presentation of the information to prepare for trial? Did you understand by entering this plea bargain agreement, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Court will find that defendant has knowingly and voluntarily waived indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Showing you what's entitled Application for Deferred Adjudication. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it?
Yes, ma'am.
Showing you the information. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the information?
Yes, Your Honor.
State, are you proceeding on the information as presented?
Yes, Judge.
Going to show you what's entitled Court Admonishments. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am. I did.
Did you understand you're charged with possession of a controlled substance, penalty group 1, less than 1 gram? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront Any witnesses the state would call in the right to remain silent.
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
My opinion, she does, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
In my opinion, she is and was, Your Honor.
Ms. Hernandez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, ma'am, I did.
According to the plea bargain agreement, there's to be a $200 fine probated. The state will take in consideration the following cases: NIMAG number 734-824, 706-758, 706-759. They're recommending deferred adjudication, and they're asking for a drug court evaluation. So just so you're aware, drug court is full, but we will ask for the evaluation, but you may not get in. You understand?
Yes, ma'am.
All right. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am, I did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement.
Yes, ma'am.
State is recommending that your deferred adjudication be for a term of 4 years. There be a TAP evaluation and 100 hours of community service restitution. Did you understand those were recommendations from the state, and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence
State offer, state exhibit 1 and all attachments.
No objection.
showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you and your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same.
And Judge, may I approach? I was
Yes.
gonna look at the court admonishments. I believe I forgot to write in possession of controlled substance and an full body. I think it's blank space. I should put it in.
Let me see. All right, you may want to look in there. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes, ma'am.
Counsel, are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
We would just pray that the court follow the plea agreement.
All right, Ms. Hernandez, when's the last time you were employed?
Like 4 months ago.
Doing what?
My dad has a lawn, he owns a lawn care.
All right, what's the name of this person you were with?
Like working.
No,
Jack
and the police
Hernandez.
report.
Oh, some homeless guy that I was out there with.
All right, we're back on the record.
It was just some random guy. I was homeless at the time. It was just some guy up the street. User.
All right. Do you have any children?
Yes, ma'am.
How old are they?
I have a 17-year-old, a set of twins that are 14, and a 13-year-old.
And where are they?
They've been adopted. They've been out of my life for, well, I'm gonna say pretty much all my life.
Okay, how often were you using?
I was using for at least 10 years.
Okay,
I've been clean for almost a year already. I was using heroin.
Well, it can't be almost a year because we're still in
barely going off like. it's
all right,
like-
because we're still in 2023. Am I right in that?
Yes, Your Honor.
And this offense was April 3rd, 2023. So you haven't been clean for a year.
That's going to, it's going on a year, right? I mean, a couple months, I guess.
Okay. All right, this is what the court is going to do. Court is going to sentence you to a $200 fine that'll be probated. I'm going to want a TAP evaluation. Follow all TAP recommendations. Sorry. Follow TAP recommendations. If they recommend inpatient treatment, she needs to go to inpatient treatment. And that's to be followed by felony drug court, 4 years deferred adjudication, 150 hours of community service restitution. The TAP evaluation is to take place in custody. Proof of employment within 45 days of release. No employment as a home health care provider or with minors. Regular reporting by Zoom or in person. We'll do the UA hotline until further notice. Field visits 1 time per month until further notice. Probation, is there anything else she needs?
No, Your Honor.
All right, is there anything else you need from the court to be successful?
Judge, she has a job, I believe, outside. But the real question is just, do we know about how long the TAP evaluations are taking right about now?
Probation, how long is TAP? 2 weeks.
Would the court consider? Well, I don't know. Would you like to explain to the court why you feel like you need to be?
Honestly, because me being sober living and my dad being back in my life, he's helping me get back into church, and I wanted to be a part of this ritual, this what is it called? It's like a woman barrier, and I wanted to go on this retreat so I can cleanse myself and actually.
Okay, let me ask you this. This retreat, does that retreat happen every year?
No, it's just like one time. It's just one time. Like I
Like they only have it one time forever?
No, ma'am, but honestly, this is what I signed up for. So I've been living with this lady and I told her I honestly would be there for her. Like, and she's.
All
she's
right,
my
so
support. I'm not.
Here's
lying.
the thing. I've read the police report.
Yes, ma'am.
There's heroin and everything else going on with you.
Yes, ma'am.
So no, the answer is going to be no from the court. You're going to do a TAP evaluation in custody. And if they recommend inpatient treatment, you're going into inpatient treatment. Do you understand?
Yes, ma'am.
All right. Have you been to prison before?
Yes, ma'am.
For what?
For intent to deliver.
All right. And so felony drug court is not going to accept her. So we can take felony drug court off the list and do a gang evaluation. What is the tattoo on your chest about?
Jesse. It's my ex-boyfriend. He passed away. I put his name. It's Jesse. That's it.
Okay. We're going to do a gang evaluation and we're going to remove felony drug court because with the intent to deliver, felony drug court is not going to accept her. You understand? Court is calling 2020 CR 0298, State of Texas versus Jesse Solis. Can I have parties announced for the record for the state?
Left done for the state.
That is for the defense. And are you Jesse Solis? All right, I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that document with your attorney? Did you understand it? Are you the same Jesse Solis Jr. who was placed on deferred adjudication in 2020 CR 0298 for the offense of assault, family second offense on August 24th, 2021, for a period of 6 years. Is that you?
Yes, ma'am.
State?
Yes, Your Honor. On or about the third day of September 2021 in Bear County, Texas, the defendant Jesse Solis Jr. did then and there fail to submit to drug testing as directed by the court officer, supervision officer, and or a duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
True.
State?
Your Honor, the state would move to deny the MTR and modify.
Are you waiving the other allegations?
Your Honor, I appreciate it. Yes, we are waiving and abandoning the other conditions.
Any objections to the waivers?
No objection, Judge.
All right, did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in prison and up to $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 2?
Yes, ma'am.
Court will find violation of condition number 2 true. Is there a proposed agreement?
Yes, Your Honor, there is a proposed agreement for SADF.
Probation? Is that your recommendation? Because I have 2 questions. 1, is that your recommendation? And 2, has he done anything on probation?
Your Honor, the original recommendation was for Bear County ISF followed by ISP. However, speaking with defense counsel, she indicates that Mr. Solis may have a drug problem. Kind of looked over that, then we said SADA. My other thought was revocation. His last office visit with probation was February 18th of 2022. Your Honor, he has not completed anything on his probation. He did initially signed up for the Veterans Prevention Program, but we don't have anything on file that he actually completed it. And then he has not completed any of the other terms.
All right, has your client done anything on probation?
No, I don't believe he has, Your Honor, but I did have my visit with him. He informed me and I spoke to his mother as well. He had a stroke in 2008. And so he's got some memory problems that are nowhere in the court's records. He's had some auto accidents in 2011 and 2012 where he's got hit by a car. And the mom did confirm the memory problems. So I did have my visit with him, he knows he's on probation. He knows he was on probation. He absconded. I obviously asked him why, and he let me know that, that he does have a drug problem and he does want help. And he's asking the court he's not a convicted felon, judge. That's why he's on deferred. So this is his first MTR. He's never been on felony probation before. He's got some misdemeanors, but he's asking the court to allow him to get some help. He's 39 years old.
All right. Mr. Solis, the court's problem is that you have not done anything. All right, this is what the court is going to do. Court is finding violation of condition number 2 true. The court is going to grant the motion, find you guilty. Revoke. Does anybody wish to speak to the time?
Nothing from the state, Your Honor.
All right, defense, do you want to speak to the time? The range of punishment is anywhere from 2 to 10 years in the prison.
That's correct, Judge. So in light of the fact that Mr. Solis is not going to be, given an opportunity to continue in his probation, I would ask that the court give him the minimum sentence.
All right. Court is finding violation condition number 2 true. The court will find you guilty, grant the motion, sentence you to 3 years in the prison, give you credit for any time served. There's to be no contact with Ana Solis and Gloria Torres. There's an affirmative finding of family violence. If you would like the therapeutic community, I can request that, but you'll need to request it as well. So if there's a drug or alcohol problem, they will address those issues with you. Would you like that?
Yes, ma'am.
All right. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
All right. This was not a plea bargain agreement. You do have a right to appeal. That right to appeal is limited, though, to the allegations in the motion, not the fact that you are on deferred adjudication. Do you understand?
Yes.
All right. Good luck to you.
Thank you.
Oh, and I'm sorry, one other thing, because this is a felony conviction and affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. You understand?
Thank you.
All right. Good luck to you, sir.
Hearing for Ashley Hernandez begins as a routine plea for deferred adjudication on a state jail felony drug charge. However, the atmosphere tightens when Judge Stephanie Boyd meticulously reviews each legal waiver, ensuring Hernandez understands she's giving up her right to a jury trial and appeal. The first crack appears when Hernandez discusses her sobriety, claiming near a year of being clean. Judge Boyd, reviewing the file, corrects her. The offense was in April 2023, making that timeline impossible. This moment establishes Judge Boyd's absolute control over the facts. The drama intensifies during sentencing. After outlining the terms, including a $200 fine, community service, and a drug evaluation, Hernandez interrupts. She asks the court to consider letting her attend a one-time women's retreat for cleansing, citing her church involvement and sober living. Judge Boyd's patience evaporates. She references the police report detailing heroin use with a random homeless guy and denies the request outright, mandating an in-custody TAP evaluation with possible inpatient treatment. The final, crushing blow comes with a simple question. Have you been to prison before? Hernandez admits a prior conviction for intent to deliver. This discovery prompts Judge Boyd to immediately remove the felony drug court option from her probation, stating it won't accept her, and adds a gang evaluation. Seeing pushback in the defendant's demeanor, Judge Boyd delivers her most devastating line. If you could write your own program, we wouldn't even be here. She then offers Hernandez a stark choice: proceed with the strict probation or withdraw her plea and go to state jail. The defendant relents, and Judge Boyd finalizes the terms, leaving no room for negotiation. This is a masterclass in holding a defendant accountable for their history, their current charges, and their attitude in court.